Right.
This is an appeal in the matter of ASO, into brackets, Iraq, and the Secretary of State for the Home Department.
Yes, Mr. Holmes.
My lord, my ladies, I appear on behalf of the appellant,
You do.
my learned friend Mrs. Skinner, on behalf of the respondent.
Thank you both for your statements and arguments. Very, if I may say so, well prepared, and they've helped to focus our discussions, pre-court discussions, and we look forward to hearing your oral argument. We think this is a relatively brief point, not necessarily a straightforward point, but relatively brief. We hope you will be finished by lunchtime. Have you had a chance to discuss the division of time?
We have, we anticipate that we can each compress our submissions to an hour, or thereabouts, with a little time thereafter for slippage and various replies.
We've read everything that we need to read, we think, focusing, of course, on the two decisions. And we're being live streamed, and we've got an anonymity order, so we must be careful to make sure that that's complied with.
Oh, yes.
Thank you very much. Yes.
I'll dive straight in then.
Please do, dive in.
This is an appeal, as the court will have appreciated, against the decision of the upper tribunal.
Yep.
Tribunal Judge Gleeson promulgated 13th of October 2021. By way of her decision, she dismissed the appellant's onward appeal against the earlier decision of the first year tribunal, promulgated about a year earlier in October 2020.
And our focus is really on the FTT's decision, isn't it?
Perhaps a mix of both, but ultimately we will need to come to the first year tribunal's
I
decision.
think we'll need to concentrate on it, won't we?
Yes. Certainly, I think given the way that arguments go to develop, yes.
Well, the upper tribunal decision wasn't very long, so there's not much to say about it in one sense. Anyway, you take whatever course you want, Mr. Holmes.
I'm very grateful. Can I turn to address very quickly the papers? You should have two bundles. One core appellants bundle.
That's it. There's a core appellant and a core respondent.
No, I've termed it that way because I think it's usually termed the core bundle. It's characterised as an appellant's bundle on the header. But you should only have one bundle of case documents, which is characterised as the appellant's bundle on the header.
What's the other one then?
The authorities bundle.
I don't think
Oh, I've got two appellants bundles.
No authorities.
Oh, I've got authorities.
Have you?
Yeah.
All right. You've got authorities?
You haven't got authorities?
No.
No.
Okay, I'm just going to send a text.
My instructions
To
list
my
has
clerk.
a spare appellants bundle. Which,
Okay,
if
No, we've got those.
okay.
I'm going to send a text, if you'll permit me to send a text. I'm going to send a text to my clerks saying
Sorry, we also have
we're
a spare,
missing- we're
a
missing
spare
two
authorities
of-
bundle.
we're missing 2 copies of authorities bundles. You're missing that.
I think they've got one. They've got one.
We've got
spare.
one spare authorities
We're
bundle
missing
as well.
one. We're missing authorities bundles. Sure.
My instructions list tells me, in fact, we've got 2 spare authorities bundles. I'm very sorry, my lord.
Okay.
that
Well, I will save my clerk from having a nervous heart attack, and if we may, we'll borrow those authorities bundles.
I'm told they're unmarked.
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 Good.
Um,
What? How wise of your solicitor
Well,
to bring that.
right.
I brought two, my lord.
Couldn't be better. We've got one. You got one.
I've got one on here.
Lady Justin's got one, and Lady Elisabeth Laing and I don't. So that could not be better. Well, it would have been better to have the advance, but anyway, there we are. Now, okay,
Those are
Mr. Holmes.
numbered because they're from the PDF.
So I've got 2 copies of the core bundle. I'm
Yeah.
assuming we're dealing with a bigger one, are we?
151 pages. It has both replacement skeleton arguments listed on the index.
Yeah, it's the big one.
Oh no, that's right. Right, thank you. Yes, right. The authority. I'm to put the authorities are actually at the back of this big bundle. So, have you got that too?
Yes, they are.
Yes, they are at the back of it. Yeah.
Not a good start, Mr. Holmes.
No.
It's entirely our fault, not yours.
But perhaps do you have enough copies for your solicitor, or does she want one back?
If your ladyship wouldn't mind, I'll
No,
take
not
one
mine.
back, but
Okay.
just so that everyone has.
Don't tell the Masters the rules about this. Hope he's not watching on.
I mean, I have to say, I think that the difference between my learned friend and I on the law is pretty narrow. So it may be that we don't actually need to
I
go to
don't-
very many
we
authorities.
did-
That's our view.
We didn't think we were going to be looking at the law. We thought it was going to be drilling down into the 2
But-
decisions.
Better, obviously, that everyone has the same
Okay.
documents.
Right, Mr. Holmes. Take 2.
I'm very grateful. Two additional documents that have been handed up
Yeah.
this morning.
Yeah.
A copy of the respondent's notice, which was omitted from the appellant's bundle,
Okay.
and also the skeleton argument before the first tier tribunal.
Okay. Right.
That should be all the court should have. I gather from the observations that were made earlier that the court has done a good deal of pre-reading. I don't propose in those circumstances to go over the factual background to the case. I've set out everything that it seems to me the court needs to know in my skeleton argument from paragraph 6 onwards. So I'll dive straight in, if I may, to deal with the first tier tribunal decision and the contentious paragraphs that will form the basis of, I think, most of the argument today. So in Court Appellant's bundle, page 57, we have the decision of the first tier tribunal following the hearing on the 12th of October 2020. There are 3 paragraphs in particular that are material for the purposes of argument today. The first of those is paragraph 36, so that's core bundle 63.
Yeah.
Now the point that seems to be made by the first tier tribunal judge at 36 is that because there'd been no apparent effort to harm members of the appellant's family, then it followed that his narrative was less likely to be true. In other words, it's taken against him as a so-called credibility point. Now, the reason it seems from that passage why the judge considers that material is because of what he regards the background evidence to say. So he cites a passage from the respondent's country policy information note. I'll refer to it as shorthand as the background evidence. Now, the passage that the judge there cites doesn't deal, in my respectful submission, at all with the risk of harm to the appellant's family members. It deals at its height with the risk of harm to parties to what I'll loosely call the illicit relationship at the heart of this case. So that's the first contentious passage. Second,
The passage in italics in paragraph 36, you say, is not relevant to the issue he was specifically considering at that point.
correct, that's the point. Next is paragraph 37 of the judge's decision. We're on the same page at the bottom.
Mm-hmm.
A little bit more of a link here, I acknowledge, between the content of the italicised material and the judge's point. The judge introduces the point at 37 by identifying the respective ages of the appellant and his then partner at the time that a marriage proposal was made to the partner's family by the appellant's family. They're both identified as being the age of 18. I think that's right, they were round about that age. The judge then goes on to cite this passage from the background evidence, dealing with, as he puts it, marrying age. And having cited it, concludes at 38. In these terms, I therefore conclude that his account of the marriage proposal is inconsistent with the known background material set out above and is not credible or reliable. And the point here is a little bit different because I acknowledge that the passage cited does have some relevance to the point that the judge seems to be making. The appellant infers that the judge is attempting to say that the ages of the respective parties at the time of the proposal are inconsistent with what this says about general ages. I'm going to come back to address criticisms of that a little bit later when I deal with the respondent's notice, because it might be convenient to really bunch all of the arguments up there together. Now, the final passage that the appellant challenges of the first tier tribunal's decision is that at paragraph 40. So core bundle 64, final paragraph on the page. The point that the judge makes here is that, as I understand it at least, the appellant's narrative is less likely to be true, so his credibility is impacted, because in fact his mother would have known what became of his partner. She must have known, in essence, is what the judge seems to be saying. And the way in which he reaches that conclusion is again by reference to the background evidence.
Well, partly because he's also reaching it by reference to the fact that they live in a small community, that S must have lived in the same small local community. They went to the same school, and he inferred that the mother would have known.
My lady's correct. There's perhaps more than one element to that conclusion. But it does seem that a material part of the judge's point rests on the italicised passage from the background evidence. That deals with, as it's put, the status of women, and it's taken, it seems, from a publication in 1960, which says, if I can respectfully paraphrase, Kurdish women doing very well for themselves in Middle Eastern cultures generally. The appellant says again that has no relevance and no bearing on the state of knowledge of the appellant's mother in this case. So those are the three key passages, and at least one of those instances the judge expressly rejects a material chunk of the appellant's case by reference to background evidence and alleged inconsistencies between that and the appellant's narrative. Jumping forward then a little, you will have read, I dare say, my grounds of appeal to the upper tribunal.
Well, do you want to say anything about any other paragraphs in the FTT decision at this stage? I mean, his conclusion is 42, is it? On this point, overall conclusion?
Yes, that's where he sums up his overall conclusion having regard to.
And is it your case? It is your case. That is tainted, or let's say affected at this stage by earlier the passages you've referred to.
Absolutely, absolutely. So for clarity, credibility was at the very heart of the appeal before the judge. If I could not establish that my appellant's account was reasonably likely to be true, then I could not succeed. I think on virtually all of the grounds. There was maybe part of the appeal that could have succeeded, but in reality, it was the central issue before the judge. Those findings that he's reached that I've drawn your attention to go towards that ultimate overall conclusion on credibility. So yes, forgive me, jumping forward then a little, my grounds of appeal dated the 5th of November 2020. Many of those have fallen away now. It is probably only grounds 3 and 4 which are relevant for today's purposes, and even then probably not relevant very much. And then we come next.
Sorry. Where are you?
Page 53.
Thank you, my lady. They start at 51.
Round 3 is on page 53.
3 is at 53 and ground 4.
Yep.
I think for completeness though, nothing turns on it today. Ground 2, paragraph 7b, also touches on a similar point, but I don't propose to make anything of that in particular.
Yes.
So look, can I then take you forward to the upper tribunal's decision, which you have at core bundle, starting at core bundle 44. There are only two material passages of this, I think. So firstly, at paragraph 21, which is core bundle 47, that's the summary of the argument for the upper tribunal. The judge characterises my submissions there as either being submissions that certain findings were not open to the judge, or that they had not been adequately reasoned. And I think paragraphs 2, 4, and 6 of 21 are all that's relevant
Those are the relevant ones for
today. And then we can jump forward a little bit further to core bundle 49 and paragraph 29, which is the spot for any bookmarks you have available. That's the key challenged passage in the upper tribunal's decision. Let me move to address then the appellant's challenge to that decision first. Two grounds upon which I was granted permission. Firstly, a failure to apply the correct test when considering whether the errors were material or not. And then secondly, failure to give adequate reasons as to why those errors were said to be immaterial to the first tier tribunal's overall conclusions. I'll say a little bit about the applicable law as to the materiality point. There's a reason behind that, because I think there's a very slight difference. It may turn out not to be a difference at all between myself and my learned friend as to exactly how the test is to be expressed. And that difference has arisen through our respective written cases. My submission is that the appropriate formulation for the court to adopt is that an error of law will be immaterial if any rational tribunal properly directed would have been bound to reach the same decision. I think three spots in the authorities that I draw that from. So I'll take you to those, if I may, as quickly and as swiftly as I can. So authorities bundle tab B. It's of SH Afghanistan.
E.
B for Bravo, forgive me.
Sorry, I misheard. Yes.
And moving forward to paragraph 15 of the judgment. Looking at the bottom third of that paragraph, so 5 lines from the bottom of the page.
Tribunals like courts.
Tribunals like courts, yes. Must set aside a determination reached by the adoption of an unfair procedure unless they are satisfied it would be pointless to do so because the result would inevitably be the same.
But that's instead of remitting it. Isn't that what they were? Was this a materiality question being determined?
It was.
It was.
It
Where do we
was.
get that?
So SH was a case where I think the court determined that there was no material error in approach by the lower tribunals. Because by the time the case came before the Court of Appeal, the evidence that the appellant had sought to adduce had been adduced, and other reasons had been found for rejecting it.
But this was a case where a report, an independent age assessment hadn't been obtained.
Correct.
And the question was the procedure fair? in proceeding without the independent age assessment. And it was only if the court could conclude that with or without the independent age assessment evidence, the court would inevitably have reached the same conclusion.
Yes.
Right.
Correct.
That's different from this case, isn't it?
Well, the point at the heart of their lordship's decision was the same.
Right.
So whether it could have been said at that time that the fresh evidence would not have made any difference to the outcome.
Yeah.
If that couldn't be said, then the judge at first instance was wrong to refuse the adjournment that was sought, and the upper tribunal was likewise wrong not to recognise that error.
So that's the first authority.
That's the first.
You've got 3 building blocks for your submission.
I have. The point about the first is that the way in which the test there is expressed, the result would inevitably be the same, tends to suggest that it might be, to some extent, forward-looking. So not necessarily looking back through the eyes of the previous judge or the previous decision maker. So that's authority number 1. Authority number 2, tab C for Charlie. This court's judgment in AJ Angola and another. If I can take you forward a handful of pages to paragraph 49 of the judgment. So the judgment here of Lord Justice Sales, as he then was, dealing with the case of AJ Angola, and his lordship there addresses a submission by my learned friend Miss Khan of counsel, who represented AJ. He rejects that submission, that the alleged errors in that case were immaterial, and in doing so he goes on to set out a formulation of the materiality test, which is ultimately where I draw my own formulation from.
Right, so you've taken it from 49.
From 49. Then finally moving forward to my final building block, tab D for Delta. Supreme Court's decision in Sadowska and another. The judgment of the then Deputy President Lady Hale, paragraph 31. Looking at line G in the margin, so the last sentence of paragraph 31. Lady Shep expressed herself in this way: it is impossible for this court to conclude that, had the matter been approached in the right way, the decision would inevitably have been the same. And then forward a little.
And the error in this case, was it an error of law case?
It was, so an error amongst other things about the application of the burden of proof
Yes.
in marriage of convenience cases. So jumping then forward a little to 33 at the bottom of that page, the ladyship goes on to say, it is not impossible that a tribunal, properly directing itself, would reach different conclusions in the case of these two appellants.
So that's the other side of the coin.
The other side of the coin,
Yeah.
but looking at a properly directed tribunal's viewpoint rather than the viewpoint of the decision maker or judge below. So those are my observations on the law.
Thank you.
The reason I say that's significant, potentially, and maybe not in this case, I acknowledge, the court will need to determine that, but the reason it may be significant is because there may be an inherent difficulty particularly in a case concerning credibility findings, in attempting to sort of take out or remove certain adverse conclusions and attempting to determine whether the judge would have reached the same decision. Ultimately, that's the error I submit that the upper tribunal may have fallen into in this case. So let me take you then now to my substantive challenge on that first ground. The upper tribunal's decision at core bundle 49, paragraph 29.
Yes.
The court will be invited to engage in a reasonably close analysis of how the judge here has expressed herself. But just before we get there, two things which I say are clear from the decision. Number one, there is no legal self-direction on the materiality point anywhere in the decision. That's important in three respects. Firstly, because there's no reference to authority. I acknowledge that's not fatal in and of itself, but it's an indicator away from the judge having had the correct test in mind. Secondly, because there's no attempt to formulate the correct test in the decision, whether by a borrowed formulation from authority or formulation in the judge's own words. And thirdly, as I'll come back to, we say it's not clear from the judge's language that in fact the correct test was being applied. Those are three reasons why the absence of a legal self-direction are important. Then the second thing that is clear from the decision, this is the only paragraph where the materiality question is addressed.
Is it mentioned, were these authorities cited to him? Her?
Her.
Forgive me.
No. I think it was the materiality point as it arose, from my fairly hazy recollection now, arose during submissions at the hearing. I think it was a point made by the Secretary of State.
Well, it was your appeal, wasn't it?
It was.
Did you put to her what test that she ought to apply?
I can't recall.
It's not in your. We've got. This is the skeleton argument that was filed, was it? On your.
Not before the upper tribunal. There was no skeleton.
That's the FTT. Have we got the skeleton before the upper tribunal?
There wasn't one.
Okay.
So I relied on the grounds that you do have, in lieu of a skeleton, as it were. So no, I don't think the judge's attention was drawn to those authorities on materiality. Now, in terms of what the judge says at paragraph 29, I say there are three elements to that passage. So first, there's the comment that the challenged passages do not add significantly to the judge's reasoning and do not detract from it. Secondly, there's the comment that they are superfluous. And then thirdly, the comment that no arguably material error of law can be drawn therefrom. Now, the appellant's case is that the key to understanding what the judge here was saying and what test she has applied in her mind rests on the word superfluous. The judge, in my submission, in using that term, is in essence saying that the challenged passages are excess reasoning, they're additional reasoning that wasn't required in order for the first-tier tribunal to reach its conclusion. So in other words, my submission is, and I'll characterise it in this way, that the judge has adopted what I'll call the blue pencil approach. So she has reviewed the decision of the first-tier tribunal. She's noted the challenge made to various passages of it by myself, and has then conducted an exercise whereby she's considered whether she can simply...
But if the material was superfluous, wouldn't the result have inevitably been the same?
If those passages were superfluous.
That's why we really need to focus on the FTT's decision, isn't it?
Yes. Very good.
Are you agreeing with what I just put to you before we move back to the FTT? I mean, if just to repeat, if I'm looking at what Lady Hale said, because that's still open in front of me. If it's the case that that those passages are superfluous, then the result would inevitably have been the same.
I accept that if there is a factor in a case which is, to put it that way, superfluous to the decision, then yes.
Okay, so Milady's right. The question is, were they superfluous?
Let me turn to address that then.
Yeah.
Were they superfluous? The appellant says not. He says not because they were material elements of the assessment of his veracity. The judge uses them to undermine his credibility as a whole and to reject the narrative that he had given as not even being reasonably likely to be true. It is said, and has been said, I think, that credibility is not a seamless robe. It requires, in my respectful submission, a holistic assessment of all of the relevant evidence that pulls one way or the other, and save perhaps in a very exceptional case, facts of which I can't necessarily contemplate, so I won't try, but save in a fairly rare case or exceptional case, it will be almost impossible for an appellate tribunal to get inside of the mind of the judge and to consider which of those reasons might be subtracted, and yet the judge would have still reached the same conclusion. So that's why I say they're not on any view superfluous. They go directly to that credibility assessment. There's one, well, I dare say there are a number of examples in authority for that point. I've set out one in my skeleton argument from SB Sri Lanka, where the same point is made about the centrality of the issues that were challenged to the judge's reasoning. So the appellant submission then on that ground is that despite the deference that the court will offer to an experienced judge in a specialist tribunal, it is clear from her language and her approach that she's not applied the correct test here.
Sorry to interrupt, Mr. Henry. Can I just ask a question? So your submission is that the task is for us is to try and get inside the mind of the first tier tribunal rather than to step back and ask whether objectively the decision would inevitably be the same without the, to use the upper tribunal's term, superfluous reasoning.
I think my submission might be the opposite.
Okay, well, so just tell me what your submission is in answer to that.
So my submission on the approach the court ought to adopt today is to avoid attempting to get inside the head of decision makers below. And rather is to take an objective approach and to review the alleged errors objectively in terms of whether or not a properly directed tribunal now would be bound to reach the same conclusion, or a properly directed tribunal would be bound to reach the same conclusion.
Right, thank you, that's helpful.
Right. So if, for example, the first tier tribunal judge has said, even if I ignore the CPIN, my finding would be the same. That would clearly be, well, you would have a harder task.
Yes, I think I would.
Your point is, it's all interwoven in a way which makes it impossible for this court objectively to pick out the strands.
Correct. So those are my submissions on the first ground.
Okay.
Second ground of appeal, failure to give adequate reasons in the alternative for the conclusion that the challenged passages were immaterial. I don't think, as my learned friend has identified, I don't think there's any space between us on the relevant law as to the duty to give adequate reasons. No. There may be some space between us as to, of course, whether it's complied with in this case. But a few general propositions that I would make, and the court will challenge me on them if it feels necessary. Firstly, the duty is contextual.
We're talking about which reasons?
So the upper tribunal's reasons
We're talking about the upper tribunal's reasons.
for concluding that the challenged passages were not material.
I see.
I think these principles will be relevant, of course, when we come back to the first-tier tribunal's decision. So first, the duty is contextual. What it requires will vary on a case-by-case basis, and also, I would suggest, potentially on an issue-by-issue basis. So the more significant to a decision the issue in question, the greater, generally speaking, the duty to give reasons for a conclusion on it. There is a basic minimum, which is some reasons, at least. And the authorities tell us that there is a need for judges to set out both the principles under which they have acted and the reasons that have led them to their ultimate conclusion. And finally, reasons must be given for matters which are material to the conclusion reached. Those are my general propositions to inform this argument. Going back then to what the judge says at paragraph 29, I've delineated the three elements of that passage. You will have gathered by now the appellant's case is simply that there are no reasons given by the judge as to why my complaints about the first-tier tribunal's decision were immaterial.
Well, is that right? She says they're superfluous. She doesn't develop that, but she does say they're superfluous.
That, in my submission, is ultimately a conclusion. And it's
That's the reason for her refusal of the appeal, for her dismissing the appeal. The conclusion is the appeal is dismissed. One of the reasons is the material was superfluous. Now, it's very short and it doesn't go on to particularise, but that's a reason, isn't it?
my submission on that, I suppose, is twofold. Firstly, I say, with respect, no, it's not a reason.
Okay.
I say it's a statement of conclusion that the judge has arrived at. These elements of the decision are superfluous. I'm not told why. Secondly, if the court's not with me on that, I say it's not an adequate reason.
But what does this add to your appeal? I mean, if we look at the FTT decision and decide that he was right in saying that it was superfluous, she was right in saying it was superfluous, we're not going to allow the appeal on ground 2. Equally, if we accept what you say on ground 1, you don't need ground 2.
Very good. I think in those circumstances, respectfully take the hint and maybe move forward to say what I want to say about the first-tier tribunal's decision.
Okay.
So back then to the core bundle 57, where the decision starts. And moving forward a little bit, core bundle 63,
Paragraph
36.
yeah.
I'll make my observations on the first-tier tribunal's decision in the context of the arguments made by my learned friend in the respondent's notice, which seeks to uphold that decision. My overarching point, I don't think I need to make, in fact, any longer. Let me move then to that first paragraph, paragraph 36. So the point here that the judge seeks to make is that the absence of any threat, or in particular the absence of any harm to the appellant's family members in Iraq, tends to undermine his veracity as a witness. Makes it less likely that he's telling the truth. Now, it's apparent in my submission from what the judge says and from the way in which the judge expresses himself at 36 that the reason he considers that to be of significance, the absence of harm to the family, is because of what is said in the background evidence. So we see that from the final 4 lines of 36. There is no evidence before me that any of the appellant's family have been harmed in any way by S's family in the manner set out in the background evidence. So he clearly links those two things together, and the background evidence is the backbone of his conclusion there in my submission. Now,
What do the word? Could it not be said that the words "in the manner" onwards are superfluous? Including the passage in the citation.
in my respectful submission, no.
Well, had there been any evidence, was there evidence before him that any members of your client's family had been harmed?
No.
No.
In any way?
No.
By S's family?
No.
Okay. So we could draw a little sort of dotted line after that.
I see.
And is that and yeah.
Well, let me unpack the reasoning a little bit as to why that may not matter, if I can put it that way. What's said against me in the respondent's skeleton arguments and the respondent's notice is that the appellant's case was that he was at risk. He is outside of his partner's family, and therefore it follows that the judge was entitled to take into account whether or not members of his family had also been harmed, as in by extension from the risk that attached to
Well,
him.
is that right? I mean, that may be what the respondent says, but what the appellant was saying to this tribunal, or at least in interviews to the Secretary of State, is that there had been threats to his own family.
I think his evidence was clarified by the time.
Well, he gave different evidence, but there were different accounts.
That doesn't form part of the judge's reasoning here for rejecting or for holding this matter against the appellant.
Well, but he says there's no evidence of any of the appellant's family having been harmed.
Correct. And that was the appellant's case before the judge. His case was that I think there's a mention of threats in the asylum interview. Those threats, he says, were directed towards him, not directed towards the family.
Although that's not what he said in the asylum interview.
No, that's how he explains
Yes.
what he meant at a later date. Now, the judge doesn't take any point on that inconsistency. The judge doesn't say, as he may have been able to, may have been entitled to, I don't believe you because you've said two different things at two different times.
Well, he does refer to consistently maintaining that he'd not said S's family threatened to kill members of his family.
Yes,
So he's identified an inconsistency.
but says no more about it.
No.
Now, going back a step, if I may, to the point I was seeking to expand upon. The issue in terms of the background evidence is this. There's no dispute between the parties that the female member of the relationship may have been at risk of honour-based violence because of her participation in the relationship at a general level, females generally. There was also no dispute between the parties in my submission that the male party to that relationship may also find themselves in harm's way. We know that amongst other things because the Secretary of State in her decision letter produces evidence on that point. So for your reference, Core Bundle 83, just above paragraph 45. But it may benefit you actually if I take you there, because there's another point to be made about what's set out.
Transgressions of honour.
That's the one.
Yeah.
So that passage, in fact, is a fairly neat encapsulation of the principle, if I can put it that way very loosely, of honour-based violence. So in essence, the point of the thing is that where a family member engages in a relationship frowned upon by the societal convention, the family honour is perceived as having been stained, as it's put, and the only way to clear that stain, it is said, is to enact some sort of violence against the parties to that relationship. The point being that nowhere in the evidence is it suggested, the judge doesn't identify any evidence to support the proposition, that that would then extend to family members of the male party, let's say. So there was rationale for the appellant's case that he would have been in danger and also potentially his partner, but nothing which tends to support the proposition that the wider family would be. And yet the judge identifies background evidence which he appears to conclude supports that.
Sorry, he hasn't expressed it very well, but isn't what he's effectively saying is, your client originally said that the threat was to his family. He changed that evidence, that account later, but that's what he originally said. There was no evidence of the appellant's family being harmed, and the country background information doesn't support that the appellant's family would be harmed. It supports that S might be harmed and that the appellant might be harmed. Isn't that really what the judge is saying? I don't know where it gets him, but that's what he's saying.
In my submission, that the passage can't be read in that way.
Okay.
I would invite the court to read it in the way that I've suggested, in that the judge appears to be holding this against him for the reasons I've set out. Those, I think, are my observations then on that first passage
Right.
of the first year's decision. Jumping forward then to the bottom of core bundle 63. Paragraph 37.
Mm-hmm.
This is the point about marriageable ages in Iraq. Now, this is one of the examples where the judge does expressly reach a conclusion in the following paragraph at 38, that directly as a result of what he says is an inconsistency between the narrative and this passage, he rejects outright the appellant's narrative of the proposal, which is a fairly material, in my submission, chunk of the appellant's account. Now, the appellant's case here is a little bit more nuanced than perhaps the point I made a moment ago. My case is that the judge here hasn't adequately reasoned that conclusion. Firstly, because the evidence was not obviously inconsistent with the appellant's narrative, particularly not when it's read carefully.
You mean the background evidence?
Background evidence. So the passage in particular, yes. And secondly, it's not adequately reasoned because of the significance of the conclusion. So the contextual duty to give reasons, I say, has some force in relation to this point. The judge rejects a substantial part of the narrative on the basis of this issue. So as to the first of those 2 points, whether or not it is, in fact, obviously or otherwise inconsistent, it's worth remembering that the first tier tribunal doesn't in fact set out in what way he considers it to be inconsistent. So we are left to attempt to draw an inference as to what he might have meant. But the opening gambit of that passage, at the bottom, caught on 3, in essence paints a fairly broad church, typical marriageable ages in Kurdish culture. The marriageable age of male and female children varies according to socio-economic class and the specific needs of individual families, and so on. Other factors are set out in the passage that follows. So no clear conclusion as to what might be a typical age and what might not be. Jumping forward then to the next paragraph of it, so over the page, core bundle 64, paragraph that starts a report by the Norwegian Refugee Council. This deals with 2 so-called focus groups of Kurdish individuals, one male, one female. In terms of the female focus group, it said that they reported that the common age for girls to marry was between 15 and 18. That's not inconsistent with the appellant's narrative. He and his partner were 18 at the time. But they felt but the best age was 25.
Mm.
You can interpret that perhaps how you will. Now, the male focus group, in contrast, it says, the male focus group in KRI felt that girls should marry at 15 to 20 years, whereas men should wait until 25 to 30 years old. Now, that's the part of it that Mullin and Friend says is obviously inconsistent with the appellant's narrative.
That's not right. I rely on the last 2 lines of this passage about the proposal and that not being refused, given the judge then refers to proposal.
I acknowledge Mullin and Friend does rely upon that final point as well. I had understood him, and it may be my error, to also rely upon that age issue.
Well, the age issue gets him nowhere, but that last sentence might be more difficult for you.
Lydia. Yes, 38 of Mullin and Friend skeleton, he does cite the age issue as well, which is perhaps where I've got the point from. But in any event, I'll take the indication on that. So in terms then of the last sentence of the background evidence, is it said that the judge was saying that the appellant's narrative as to his proposal was not to be believed because it contrasted with the view of one woman from the hook? It might be different, not in my respectful submission inconsistent, if that indeed is what the judge ultimately was driving at. So there we are. Given the significance of that point, I do say more reasoning is required. Finally then, the third point, which I think will be my final substantive submission, paragraph 40 of the judge's decision, Corbin 64.
60-year-old book. 1960 book.
1960 book. I accept my lady's point made earlier on. It's not the only reason given for the judge's assessment of what must have been the mother's state of knowledge. It does seem to be a material part of the reasoning in my respectful submission.
Well, he says I've taken it into account.
He does. I dare say you will have grasped my point about that passage already. A, its age. B, it is, I would suggest, probably irrelevant to what the mother knew or did not know. It may not be necessary for me to make analogies with the United Kingdom, any particular person's state of knowledge, notwithstanding their social status. So the point being that there's at least, or there was at least, a real prospect, had the upper tribunal applied the test correctly, that it may have concluded that these passages and the errors I allege were material to the outcome.
So do we need to just go back up to 42 and just see, are you going to come back to 42? That being his ultimate conclusion?
Yes, so the ultimate conclusion there draws together, as it were, the threads that he's set in motion in those preceding paragraphs.
Although you haven't looked at 39 and 41, which are separate from the country background, aren't they?
They are. I haven't addressed them. I don't propose to.
No.
The reason being
Those
that
are other strands.
those are other
You
strands.
accept that.
Yes.
You're not saying there aren't any other strands. Your point is you can't unravel, unthread the strands, unthread the strands.
Yeah.
Unravel, what?
Unravel a strand.
Thank you. Whichever verb you want from my
Yes.
the lady's lexicon. No, but that's your point. Your point is yes, there was other material there, but it's intermingled. grasp your point, even though I can't articulate it very clearly. But that is your point, isn't it?
That is my point. Can I assist any further?
Very clear, thank you.
Okay. Thank you very much. Well,
Bang on.
bang on. Even alive for the hiatus at the beginning. Just go.
I anticipate, my ladies, that I will be less than an hour.
Yeah.
I'm grateful to my learned friend for having taken the court already through the decisions. I don't propose to repeat any of that. Given the point that was made at the outset by my learned friend about what the actual test is for materiality, I do just propose to spend a few minutes on that, if I may.
Yeah.
The difference between us, as I understand it, is not as to the would have, could have element of the test. It's, are we looking forwards, backwards, or objectively? And my submission is that we are looking back to what the judge under appeal would have been bound to do without the errors.
We're not looking objectively at the evidence.
We're not. And it, there may not be any real difference between those two formulations, or between objective and backwards looking. There is a difference, and this is why I raised it in the skeleton and why I took the point, is that there is a difference between the backwards looking formulation and the forwards looking formulation. In fact, there are two. The danger with a forward looking formulation, in my submission, is that it allows the possibility of other evidence that wasn't before the judge that might be forthcoming on remittal to be taken into account in the question of materiality. And that, in my submission, is plainly not what's intended. The court will be well aware that obviously in human rights and asylum claims, the proper process is for a fresh claim to be made. If there's fresh evidence, you don't get another bite of the cherry to go around the system without having let the Home Office consider matters again themselves. And the second reason why a backwards looking approach, as I've termed it, is appropriate in my submission, is that there are cases where, including credibility cases, where it is possible to say, this judge, had they not taken into account this particular piece of evidence which they've given weight that it wasn't entitled to, or they misunderstood what was said, or this particular piece of evidence, if that hadn't been taken into account, they would nonetheless have been bound to reach the same conclusion.
But isn't the safer course to adopt an objective approach to the evidence? Because are you saying that there's some peculiarity about the particular judge?
No, I'm not. And that's why I say it may be that objective and backwards looking may in fact be the same thing. If one's looking objectively at it, what one is doing is looking objectively at the judge's own reasons and whether...
And the material that was available.
Exactly. But what one isn't doing, and this was, I think, with respect to the error in my learned friend's submission, is saying whether any properly directed tribunal would have been bound to reach the same conclusion as the tribunal appealed from reached. Because if you've got 100 negative credibility findings and you've got one piece of evidence of very, at best, tangential relevance, it might be that a different tribunal, properly directed, could rationally have come to a different conclusion about that individual's credibility. If one's looking at what the decision maker did, you have to see it in the context of the other findings that aren't affected by the error.
What do you say about the passages that Mr. Holmes cited? In particular, the second and third passages, the passages from A.J. Angola and from Lady Hale and Sadowska.
So there are, I think there are 5 authorities, I'm afraid. I think 3 of them have already been referred to. But there are 2 Supreme Court authorities, one of which is Sadowska. Sadowska, if I can just bring it up. Sorry, I've just been logged out. If you can watch it, so bear with me. Sadowska is tab D. Paragraphs 31 and 33 were those to which my learned friend referred.
Yeah.
Paragraph 31, the Lady Hale
She uses the past, and to paragraph 33 she uses...
Well, Yes and no. In para 31, she
future.
certainly does use the past. Had the matter been approached in the right way, the decision would inevitably have been the same. And in para 33, my learned friend relied on this for the properly directing itself. But in my submission, what she says in the second sentence, beginning at the end of the
Yes,
second
yes.
line,
She repeats it.
had the matter been
Yeah,
approached
it's the same.
in the right way.
Yeah.
And so in my submission, the first sentence has to be read in light of the second,
Yeah.
which is adopting a backwards-looking approach.
Yes.
The second Supreme Court authority is Rupiah, which is the next, which must be E in the bundle, and it's page it's page 54 in the PDF, or internal 5552. It's paragraph 58. It might be the very last paragraph in there.
Yeah, it's the last page.
And one sees 4 lines down, was the error material? Then there's a consideration of that on the facts. In the absence of his error, i.e. Judge Blundell's error, it might properly have led him to uphold the claim, and therefore the error wasn't material. So again, Lord Wilson there is looking backwards. The 3 Court of Appeal authorities on this, the passages are cited in my learned friend's skeleton, and I think, despite the fact he took you to the authorities bundle, if I might, I'd just deal with it by reference to the passages cited in his skeleton. It's core bundle, page 21, paragraph 21 of the appellant's skeleton. We see Detamu, which was a case all about materiality. The question was, would the adjudicator have been bound to have reached the same conclusion, notwithstanding the error of law? And then I'll just deal finally with AJ Angola, which is at the bottom of the page first. If it is clear that on the material before the tribunal, any rational tribunal must have come to the same conclusion, I appreciate the use of the words any rational tribunal, but that's just saying on the materials before the tribunal, absent the error, would the decision have been the same? And then just dealing with SH Afghanistan, my Lady Justice Simler picked up that this was a case about an adjournment on procedural fairness grounds, and the point is expressed. My learned friend drew the court's attention to the result would inevitably be the same as an example of a forward-looking description of the test. But if one looks at the beginning of that quoted passage, the question for the upper tribunal on appeal from the first tier tribunal was whether it would have been pointless to wait for the evidence as to age. And so the expression there in a forward-looking sense, the latter passage there that my learned friend relied on, is looking at what the judge would have been thinking in the first tier tribunal in deciding whether to grant an adjournment, which is inevitably a forward-looking exercise. So that's where that comes from in my submission. So in my submission, there are those 2 reasons of principle that I outlined at the beginning, and those 5 authorities that all point all in one direction, subject to, I mean, saving Detamu, the question of materiality and what it meant wasn't itself, I think, the subject of argument. And so obviously there are some, what I don't even want to describe as infelicities of expression, because they're quite properly expressed in the context of the judgments in which they were made. But those are my submissions on the test. The question is what would the judge or the tribunal is probably a more neutral way of putting it, because I as my lady suggested, it's not a case of looking at the idiosyncrasies of this particular judge in it, and I don't want to be misunderstood to be suggesting that. But the importance is that one does have to look at the other elements of the judge's reasoning in determining whether or not the errors, if they were errors, were material. Just in terms of legal principles, as my learned friend says, they're not in significant dispute, save for that one point that I've addressed. As I understand, my learned friend accepted before the hearing, when we were discussing what goes in the authorities bundle, that he accepted paragraphs 14a and 24b of my skeleton argument. And as I understand his submissions today, there's no real dispute between us as to paragraphs 12, 14, 23 or 24 of where I've set out legal principles relevant to this appeal. I don't.
Can you just repeat
Of
that?
course, my lady. So before the appeal, it was expressly accepted that 14a and 24b
Yeah.
of my skeleton argument were accurate. And as I understand it, there's no dispute that 12, 14, 23 and 24 are accurate. I had put 12 to 14 in my speaking note, but 13 is what deals with this forward-looking, backward-looking point.
Yeah.
I propose to leave the law there. You've got my skeleton, and I don't think any of the propositions are terribly controversial in any event. My learned friend, I thought was going to drop the point about whether the judge committed an error in not identifying the test to be applied, but it then sort of came in by the back door as a way of bolstering the submission that she hadn't applied it. It's clear in my submission that a judge that well knows, materiality of an error of law in the upper tribunal is, I described it as my bread and butter. I described it in my skeleton. It is an issue in every single statutory appeal that the upper tribunal decides.
Yeah.
I've set out in my skeleton. Judge Gleeson is obviously a very experienced upper tribunal judge as well, and so is entitled to be taken to know the relevant case law on such obvious issues that arise day to day. And that being so, and the fact that it's well established that you don't commit an error of law by not stating the test, means that from the fact that she hasn't stated the test, you can't infer that she hasn't applied it. One has to look, and you'll have seen the language in the case law as set out in my skeleton, that when one's looking at this specialist and experienced tribunal, one has to find errors by virtue of very clear language in the decision which indicates that there's been a misdirection. And in my submission, there just isn't. It isn't clear from her language in paragraph 29 of Judge Gleeson's decision that she misunderstood the test for materiality. As I think was said in discussion between the bench and my learned friend, if a evidence is superfluous, then it follows that it's not material.
Yeah, it may well be, and certainly I think we were steering Mr. Holmes towards the fourth element of his first ground, namely whether the impugned passages were in fact material to the decision.
Can I just touch on the proper approach to that for this court? There's just one other sort of legalish point. Whether something is material is a question, of course, of assessment of the evidence that was before the tribunal and the reasons they gave and the findings they gave. There is no rationality challenge. The grounds do not assert that the finding of immateriality is irrational. The grounds are simply error as to the test that was applied and failure to give adequate reasons. Those are the two grounds on which permission to this court has been granted. It is, I don't want to go off piece too far, but it's important to remember that the question of materiality comes in a statutory appeal to the upper tribunal, because if an error of law is identified, the tribunal then has a discretion under, I think it's section 12 of the Tribunal's Courts and Enforcements Act, whether to set aside the decision or not. And obviously it will normally exercise that discretion, but it won't do so if the errors are immaterial. So it comes to at that stage, and effectively, however, the different courts have put the test in very slightly different language. What the real question underlying all of this is, are the errors so tangential, so irrelevant, that there's really no point in remitting it back, and it would be a waste of the court's time? It's very similar, I would suggest, to the policy rationale behind this is very similar to that would apply to a summary judgment application in civil courts. Are we taking up more court time unnecessarily with pointless things? Now that is, although the threshold has been expressed in various ways, and it's tolerably clear that it's a high threshold, and don't seek to go anywhere behind that. There is an element of judgment and assessment that a judge has to do in deciding whether or not the errors that are found are material. And it does seem to me that the question for this court is therefore whether or not the judge was entitled to find that the errors were material, not whether she was wrong, or I don't mean wrong in the CPR sense, but not whether she was wrong too in a sort of black and white sense. Now, I do accept that the scope of the decision making is going to be relatively narrow because of the height of the threshold. And it may be that in most cases, this court looking at the reasoning of a tribunal below, it may be that there's only a paper difference between an entitled to test and a right and wrong test in this context. But it, as a matter of principle, it does seem to me that, or in my submission, it is the case that was the judge entitled to find that that the errors were immaterial. Not whether she was right or wrong to do so. So it's not a pure objective test for this court. It is a review type exercise.
Do you want just to cite an authority in support of that proposition, just to buttress it?
Well, I don't have one, but it seems to me to follow from first principles that just taking it in stages, it's a question, a multifactorial assessment that requires an element of judgment and evaluation. Those are typically questions where different judges might reasonably come to different conclusions. And it's difficult to see why, in the context of a reason for not exercising discretion, or exercising discretion, whichever way the land lies in the particular case, that same approach wouldn't be taken.
Would you like to just illustrate how something could be, we could have a case where the judge was not entitled to take something into account in this situation, but was not nonetheless not wrong?
Entitled but not wrong. Is that what you said?
What about,
It would have to be entitled
he was
but not wrong.
He was in. No. The question. Well, do you see the point? Could you illustrate the distinction?
So I think,
or is it a distinction without a difference?
Is it to do with there being a range of reasons open, so that you can't say in the entitled situation there are a range of different judgments that could be reached, and if the judge is entitled to reach the judgment she came to, we don't interfere.
Precisely.
But then there are other cases where there is a right or wrong answer, and she is right or wrong.
That may be right. Well,
but I'm not sure that any of this matters.
No, I think that's probably
because
right.
In this case, we can look at the reasons given by the FTT, and we can form a view about whether they are reasons that
Whether she would
disclose
inevitably
errors.
would inevitably come to the same decision.
I don't disagree with that in any way. The reason I raise it as an issue is just because there was some discussion about whether it's an purely objective test when one's looking at between the bench and my learned friend when he was making.
That was about the FTT though. That wasn't about the UT. That was about whether one looks at what the material was that led to the conclusion that the appellant was not credible or reliable in relation to his account of his illicit relationship with S.
Fine. Well, if I've misunderstood and it wasn't a question about the upper tribunal's approach, then I'm happy to move on.
I think
Certainly,
we're focused on the FTT.
We really. I mean,
Maybe I'm wrong.
I mean, I don't. Yes. I don't think, but yeah, I think we are focused on the FTT.
I don't disagree with that. I agree that we are that the court is going to be focused on the first tier tribunal's decisions. Save that insofar as the case law makes it clear that when one's looking at a specialist and experienced upper tribunal judge as well as the first tier tribunal judge, one needs something clear in her language to disclose that she applied the wrong test.
Yes, I mean, there's not much in her language, is there? She didn't give us much to go on.
No, she didn't.
No.
But Did she apply the right test? I say she did.
We can only tell by looking at
Well,
the FTT.
Even
Well-
if she applied the wrong test, we're not. Are we going to allow the appeals going to turn on whether the FTT?
But the
FTT
reason that
I've got Lady Hale's phrase in my mind, maybe a simplistic way. That's really what I'm asking myself. For my part, I think the appeal turns on that. Would
I'm about to move on to the first tier tribunal, but
I don't want to lead myself astray.
No, I think
If you think I'm wrong,
no,
we're
I think
wrong,
you're
you should say so.
entirely correct in that approach. But just in relation to the shortness of Upper Tribunal Judge Gleeson's reasoning, it's important to remember that Upper Tribunal judges are entitled to draft their decisions in the context where this court and the Supreme Court have said they're entitled to approach matters on the assumption that they know what they're doing, they know the case law, and we obviously all are familiar with the case law on reasons that it's directed to the parties principally, and that reasons don't have to be elaborate. They
Don't have to be elaborate, but you might have expected more than she gave.
You might, but in my submission, when one looks at the passages in the first tier tribunal judgment, which I'm about to come to, there was no need for her to go further than she did.
So I suppose one way of putting it might be to ask whether the use of the word superfluous is an adequately accurate proxy for was it material? And I mean, you might think it is. I don't know.
Well, it seems to me on the language that she did use, that superfluous plainly means it can't have made any difference whatsoever.
There you say. Here's a very experienced judge, and she knew the test, and that's pretty close.
That's
It may not be a paraphrase which we would endorse, but it's clearly indicates she had the test in mind.
Exactly.
Okay.
Turning then finally to the first tier tribunal's decision and reasons. I'm going to take the passages in the same order that my learned friend did, starting at paragraph 36 on page 63. I would endorse the dotted line that was proposed in this paragraph, that there's no evidence before me that any of the appellant's family have been harmed in any way by S's family. One can simply put a full stop there, delete everything else, and everything. It's very difficult to see how, if you delete that passage, anything that precedes it would or could have been any different.
And what was the relevance of it? Why did
Well,
it matter?
So it comes to the point that your ladyship's already indicated you're alive to, which is that the way in which the appellant put his case in interview was that his family had been threatened. We see it paragraph 19 of the first tier tribunal's decision, this is page 60. This is just recording the evidence, but when questioned about his answer given an interview, we don't have the interview in the bundle, but when questioned about his interview in interview, he stated that when he said that his family had received threats from S's family, the threats were that they were going to kill him, not kill any of the members of his family. So it was the appellant's case that his family were originally, not before the tribunal, but it had been his case that his family were at risk. And in any event, my submission on this paragraph is, quite apart from the full stop point, is that when he says in the manner set out in section 7, all the judge is doing there is saying as an honour crime.
Okay.
He's just, all the judge is saying is there's no evidence that they've been harmed as part of any sort of honour retaliation. And it was unnecessary.
You say
that's it.
37 is that. The rest of 37, including the quote, is superfluous.
It is superfluous. It's completely superfluous for anything. I mean, the other point to note about 36 is that the judge doesn't draw any credibility, any adverse credibility from that paragraph. There's nothing in the judge's language, at least, that suggests.
Partly the way it's structured, because in paragraph 36, the judge sets out some findings or observations which are supported by what you say is a superfluous passage afterwards. But of course in 37 and 38 it's the other way around. He cites the passage and then reached the 37 and then reached the conclusion 38.
Well,
I therefore conclude.
Yes and no. Yes, but there's 36. The question of whether S's family had attacked the appellant's family wasn't an issue by the time it got to the first tier tribunal. His evidence was no. And as he said, there was no evidence before him.
No.
So it's not. It's difficult to see how you can draw a negative credibility finding from a fact that wasn't an issue.
Okay.
I just don't see that
What about
goes to.
Moving on to 37 and 38 then.
So 38, the way I read this is that 37 starts by saying, well, they would have been approximately 18. Let's look at the C-pin. We then see the C-pin. There's no comments on what he could have said is before that last few lines said, okay, well, they're 18, but there's also this evidence that actually when a girl gets a proposal, the family accepts because it's not socially acceptable, and I therefore conclude that his account of the marriage proposal is inconsistent with the known background evidence. There's nothing about that.
Okay, well, can we look at it in reverse? His conclusion is that it's not that the account of the marriage proposal is not credible and reliable. That's his conclusion. Working backwards. What is the evidence upon which he comes to that conclusion, apart from the background material? They were 18. Apart from what's in 37, is there anything else?
Well, there's
the contrast between their ages and what he's been told about the ages in the background material, and then there's
that is a contrast. I don't accept that is a contrast necessarily.
Okay.
But
okay. Well, there is, which is not admitted, there is if there's a contrast, or there is a comparison. You say there's no contrast.
he says this is what happened. This is what the background evidence says.
Okay, and then the last sentence, the one woman from Dohook. So, what apart from that material in 37, what else is there that he draws on, reaching his conclusion that the appellant's account about the marriage proposal was not credible or reliable?
Well, I don't mean to be unhelpful with this response, but I suspect the proper answer is all of the evidence on all of the other matters, because credibility has to be assessed in the round, and that includes necessarily the vague manner in which the appellant gave his evidence, and the other aspects of the evidence on which he didn't find the appellant's account to be credible. I don't think it's, with respect to my own friend, it's not helpful to draw out one particular aspect of the.
But he expresses this conclusion. I mean, it could be dry. I know drafting judgments are under enormous pressure. And
Well, this is
we
one of three that he would have
must
heard that day.
guard ourselves against over too strict an analysis or criticism of the way judgments are drafted and decisions are drafted. But the fact is, this conclusion expressed at this point, immediately after 37, it's not. He doesn't recite it all out, all the evidence out,
No.
and then draw all his conclusions at the end. He comes to a series of findings in the course of the analysis.
I accept that. But the important point for my purpose is that the conclusion is related to the credibility of the marriage proposal, not as to whether or not marriage between 18-year-olds was itself credible, likely, whatever words you want to, reasonably likely. And so when one looks at that reasoning, it's tolerably clear in my submission that what he is saying is inconsistent with the background evidence is the marriage proposal and the fact that it was refused, when the background evidence was that families don't refuse marriage proposals in this culture.
What do you say about Mr. Holmes' point that it's quite a thin piece of evidence at the last sentence?
The first point is that this isn't a rationality challenge and it wasn't a rationality. The grounds weren't rationality grounds to the upper tribunal. So it was never challenged on that basis. It was said that there was an error of fact in the objective and in the sort of the E point, sort of.
Okay.
style, and so that's really, I mean, that's a complete answer to that.
Okay.
I accept that this is a piece of evidence that different judges could have evaluated in different ways and might have ascribed different weight to. But it also was as far as I'm aware, my learned friend was there, so he'll correct me if I'm wrong. But as far as I'm aware, it was the only evidence as to what happens with marriage proposals that was before the first tier tribunal.
Okay.
So it's certainly not anywhere near the high threshold that would have been required for a perversity challenge before the tribunal.
Yeah. Okay, does that deal with 37, 38?
It does.
So then we come to the last passage, relied on by the appellant, in 40.
Yes, 40. I accept, obviously, that the background evidence, the CPIN, was a reason for finding that the mother would have found out, the appellant's mother would have found out about S's fate, as it's put. The way in which I read this as being relied upon is effectively to say women in this part of the world aren't in quite such an intolerable position as women in other parts of the world. They find out of their own volition, not, for example, I mean, I'm obviously going, this isn't what the evidence says, but this isn't a case of a culture where women stay at home all day, every day, find out all their information about what's going on in their local region via their husband or other family members. This is basically saying the mother would have learned of S's fate after the appellant left Iraq, and then we look at the status of women. Firstly, because it's a small community, that's obvious, and as we know, and this is obviously somebody who the appellant's own case was, his family knew that he was in love with this girl. They went and proposed to her family on his behalf. You know, this is somebody who you might think the mother would have a more than passing interest in. And then you get this passage that just effectively says Kurdish women in this particular culture have influence and will go out and find things out. That's all the judge is saying. I don't think it really goes further than that. And that's not perverse. That's quite one might think it's a perfectly sensible way of looking at it. Think about, well, what is the position of women in this country? Would she be likely, therefore, to have found out? Well, it's a small community, and yes, there's nothing that would have stopped her from finding out. That seems to me to be the proper reading of this paragraph. And in those circumstances, there was no error of law by the judge in this paragraph, and to that extent, it's also superfluous, as the Upper Tribunal put it, because it wasn't, you know, unless there was some evidence that women in this culture did live some sort of very closed, sort of encloistered life, there would be no reason to think anything other than in a small community like this, she would likely have found out about the fate of the person to whom her son was intending to get married.
So it was a conclusion he'd reached, but you say he just added this CPIN, but it didn't alter or detract from the conclusion.
I do say that firstly, and then if I'm wrong about that, I say, well, he was perfectly entitled to take that into account anyway, and that's really the second of those is the respondent's notice point.
And then the ultimate conclusion is paragraph 42.
It is. It is.
And what's your submission as to how the so-called impugned passages feed into that conclusion?
So the question is, in relation to materiality, is assuming they were errors, would they take either individually or collectively, depending on how many of them were erroneous, would the judge have been bound to come to the same conclusion in any event? And it's the conclusion that is the important point.
So the specific conclusion is what?
That the appellant was not credible or reliable in his claim that he had a secret relationship with S, etc. And that was the basis.
The whole of 42 is the conclusion, is it? Well, the first sentence of 42 is a conclusion.
Yes, it is.
And the last short sentence is part of the reasoning.
Yeah, exactly.
Okay. I mean, the marriage proposal is part of the conclusion in 42, isn't it? the first sentence in 42.
It is, yes.
Would it be fair to assume, therefore, that the reasoning in 38, drawing on as we've agreed on 37, is part of that? Is a strand in that conclusion, that aspect of the conclusion in 42?
Yes, it is. It's part of the reasoning, but that's not the same question as whether or not, if you removed those parts of the reasoning, it would make any difference.
So on what basis do you say that if we removed that part of the reasoning, or if it was removed, the judge, use Lady Hale's phrase, would be bound to come to the same conclusion? It's not her phrase, but I'm paraphrasing.
Because when one strips out those italicized passages from the CPIN, you are left with either the same reasoning, because those passages are genuinely superfluous to the reasoning, or when you take the judge's credibility findings as a whole, including those in, I think it was 39 and 41, to which your lordship drew my learned friend's attention. Excuse me. It all fits together in such a way that this is one of those cases where the judge would have been bound, in light of all of those matters, to reach the same conclusion in relation to the appellant's credibility on these issues, or on the issue of the relationship.
What is the evidence in 39 that leads to the conclusion that the appellant wasn't credible in his claim that there was a secret relationship while she was at school, which became intimate on one occasion? Where's the evidence in 39 that relates to that?
So 42 is in my submission just a summation of everything that's being considered
Okay, so,
in the
right.
proceeding.
Well, leaving aside the marriage proposal, which you say can be, where is his analysis of evidence which leads him to the conclusion the appellant's assertion that he had a secret relationship with S at school, which became intimate on one occasion, was not credible?
Well, if one looks at paragraph 34 at the beginning of this section,
Okay.
you see that that's the summary of his case.
Yes.
And then at 42, that's what's rejected as a result of all of the reasons that are set out here.
Well, what are the reasons for rejecting that, as explained in this passage, 34 onwards?
I mean, I don't think there are any specifically, but that's not problematic, because what the judge is doing is saying, you're not credible. I don't believe your account of your relationship for all these reasons, and because you were vague, etc., etc.
What reasons?
Well, that
the vague. I mean, the vague. You're right.
Your evidence was vague. Your proposal was contrary to the rejection of your proposal was contrary to some background evidence. There's no reliable evidence that S's family were aware of her fleeing to a refuge centre. You're speculating when you state that they must have discovered that he organised her flight to the refugee centre. No evidence that S's family alerted any relevant authorities that S had been abducted.
Okay.
I mean,
So he's not actually. I'm sorry, I'm pressing you. It's crucial. He's not. He doesn't actually identify any evidence on this about the specific points about the relationship at school and the one occasion of sexual activity. But he finds they're not credible on the basis of the other matters alluded to at 35. 39.
The only evidence of the relationship at school and of the sexual relationship in the father's car was his say-so.
His say-so.
And so the question then for the tribunal is, do I accept or reject it?
And in deciding that, I look at the other things he said, and
Exactly.
I don't accept the other things he said. So consequently, I don't accept his their assertions on those issues. Thank you.
Can I just have a quick look through my speaking note? I think that's probably it, but I just want to make sure.
I'm so sorry I interrupted you so
No,
much.
not
I
at
know
all.
it's very irritating.
No, not at all.
Anything else?
No, I think that's it. Unless
How about you? Any questions?
No questions, no. Thank you very
Thank
much.
My lord, my ladies, 4 points,
Okay.
5 minutes, I hope. Firstly, just on the appropriate test to apply materiality, just to address one of my friend's submissions on this point. He pointed the court to a potential danger in adopting my formulation, which he says is that the court, the reviewing court, might be tempted to have regard to additional evidence that wasn't before the judge or the decision maker below. That's not a danger that arises, I would suggest, out of the formulation I proposed, which is whether the rational tribunal properly directed would have been bound
Would have been bound.
to reach the same decision. And it's also addressed directly by the passage I cited from AJ Angola, where Lord Justice Ailes, as it then was, makes express reference to the material that was before the tribunal. So that's not a concern.
So you both agree it's on the material that was before the tribunal?
Absolutely, yes. There's no movement between us on that.
So you were right, there's no difference between you. You say. Yes. Second point.
Second point that comes from that, so I'm still on the materiality point. My learned friend, in his submissions towards the end, invited you to adopt what I say is the prohibited blue pencil approach. So can certain parts of the decision of the first tier tribunal be ignored and the remainder still stand? I say that's impermissible. I say at least in part because that requires the appellate court to try and get inside the head of the judge to assess what may or may not have been of greater significance in the judge's overall reasoning. There will be cases, I think we've already identified, where it's obvious, so the judge may say, here are 10 reasons why I don't believe you. For those reasons alone, I wouldn't believe you. Here are 10 more, for example, or some device of that nature. But this certainly is not one of those cases in my submission. And it also creates the difficulty that the appellate court then has to try and assess how many reasons are enough, how many reasons would inevitably have still led the judge to that same conclusion, even if we subtract a certain number of them. So those are my observations on the materiality test. Second point, to the extent that my learned friend suggests that I needed to bring some sort of rationality or perversity challenge, my submission is that I did not. There are 2 reasons for that. Firstly, because I rely upon the contextual nature of the duty to give reasons. So in circumstances where the point is significant, the reasons may nevertheless be found lacking. But secondly, and this relates in particular, a little bit narrower, to the approach of this court to the upper tribunal's decision that the point was immaterial. There's suggestion in the authority of Detamu, which is at tab A of your authorities bundle, and paragraph 17. That it is for this court to consider the materiality question for itself.
About the fifth line of paragraph 17.
Yeah.
This is Lord Justice Moses, is it? Yeah. Mm-hmm.
So that's my point 2. Point 3 just relates to my own friend's submissions on paragraph 38 of the first tier tribunal's decision. Ever so slightly, if I may respectfully say so, a moving target on this point. You'll recall that my learned friend corrected my submissions on the issue as to which element of the background evidence that he said was inconsistent with the appellant's narrative. At paragraph 38 of his skeleton argument, he does very clearly make the point that he suggests that the age of the appellant at the time he married was, as he puts it, obviously inconsistent
Well, he's thought better of that. Does it get you anywhere?
Perhaps not, but the point developed a little bit further in my submission when he addressed the conclusion at 38. The submission now is that, in fact, as I've understood it at least, 38 represented some sort of holistic assessment of factors that had gone before that led the judge to that conclusion at
And
38.
after, I think, as well. I think he was saying it was part of the overall conclusion and it shouldn't be seen as a stepping stone.
Yes.
I hope I didn't misunderstand what he said.
My submission is there's no warrant for reading the judge's decision in that way. It's apparent that it is a discrete conclusion about a discrete issue that the judge then does come back to when he reaches his overall conclusion at 42, and it's one of the material points that he has regard to at 42. And then my fourth and final point, just a reminder really, I suppose, in terms of language, given how we've spoken about the so-called credibility assessment today. It wasn't for the first year tribunal in ordinary terms to believe or disbelieve the appellant. It only needed to conclude whether or not his account was reasonably likely to be true. Nothing may turn on that today, but the distinction is an important one in my submission when we consider the appropriate standard of proof. Those are my submissions, unless there's anything further.
Anything else, Sigrid? Right, do you want to talk about it before we rise or just rise now? Do you want to talk before we rise or should I just rise and say pleasure reserved? No need to talk. It's okay. Right. Well, thank you both very much for your submissions, which, if I may say so, have been extremely well expressed on both sides, or in writing and orally this morning. Extremely helpful. It's not a straightforward decision, and we're going to reserve it. In the usual way, a draft judgment will be sent out to you in due course. We'd be grateful if you would read and that and let us know of any typo errors or errors of fact, minor errors of fact. It's not an opportunity, obviously, to re-argue the case. I know you wouldn't do that. Bear in mind the rubric at the top of that judgment warning you that it's a contempt of court to pass it on, disclose it without authority to anybody else. And then in due course, when we've had your typos back, we'll hand down our final version of the judgment. It would be helpful if when you do that, you could let us have an agreed draft order reflecting our decision. If there's any disagreement on any subsidiary issue, we'll resolve such a disagreement on the basis of written submissions, which would be great for you if you would provide brief submissions if there's any issue. Thank you very much.
Court rise if able.